1.2 million pages of disclosure would then go into that file, into that dossier. You'd say that takes a while to read. Now, that's too easy. What does it take to read? I read 1,000 pages a day. That means for 1.2 million pages, I need 1,200 days. And that means 6 years of 215 working days a year. I don't take any holidays. So I was thinking about what that would mean to have a dossier. Or would it be better, like in that unfinished case, to digest what was presented in court through close to 250 witnesses at the time, 46,000 pages of transcript, an average of 200 pages for each witness, 85,000 of pages of OTP exhibits, and then I'm ignoring the 100 videos that should be added to that. You understand, I was trying to compare what in the one system and what in the other system would happen. I also asked myself, what about written statements rather than oral testimony? That saves time, isn't it? Okay, it saves time. We urge the parties to use written statements, and you get now 50% of the time we originally had in mind to present your case, originally in mind that all the evidence would be presented by viva voce witnesses. Again, let's think about what that really means. Let's start from the assumption that a viva voce witness takes 2 hours in examination chief. That means that if you have a written statement, perhaps with some additional questions, you can present that same evidence in half an hour with a written statement. So we have reduced the time for case presentation to 50%. That means for every 2 hours, you only get now 1 hour. In that 1 hour, you can present 2 written statements. That means you suddenly have enlarged the body of evidence, because of that 1 hour, that's 2 times 30 minutes, which also means that 2 times the amount of time needed for cross-examination of the witness. 2 times to process that evidence and to make it find its way into the judgment. So at the end, you ask yourself, was this 50%, was that a good idea, yes or no? Where are we gaining time, and what are the consequences of such decisions? Are we too generous if we give half of the time? Now, unlike in my dreams, in law, efficiency is not dealt with directly in our rules. The rules are governed by principles, and for criminal procedure, mainly principles of fairness. And then I asked myself, the basic rules of fairness, but let's say Article 6, European Convention on Human Rights, Article 14, International Covenant on Civil and Political Rights, do they make any distinction between the civil law tradition and the common law tradition? Fairness is basically to be found in both systems. Now that's interesting. First, in both systems, fairness is the bottom line, and none of the systems in itself is more efficient than the other. So what we should do is we should use the features of the system adopted in the ICTY so as to make the trials as efficient as possible. We should not blame the choice of the system. And I do understand that you can't change the system entirely overnight. I remember when I was still appearing before Judge McDonald, sometimes we were inclined in the morning to first ask, have the rules been changed overnight? The system is not the culprit. At the same time, if it takes a lot of time, one should not be surprised that if we are expected to try cases in a representative way, covering many years, tens of thousands of victims in individual cases against the accused, facts that occurred in 10, 20, 30 municipalities over a series of years, and where it took us 18 years to have all the accused transferred to the tribunal. And if we are expected to all try them fairly, that this takes some time. Apart from that, many of the circumstances are totally beyond our control. Health of the accused, cooperation received over the years from states, and a very simple fact, a distance of well over 1,000 kilometers between the former Yugoslavia, where the witnesses are, and The Hague. But despite these matters beyond our control, we have to ask ourselves, have we been inventive and creative enough within the limits of fairness? I'll not elaborate on all the rules we have adopted. President Robertson has said a lot about it. We have heard other information. But just to give one example, if you think of the concept of adjudicated facts, almost completely unknown in either system, and which really adds much to the efficiency, and I think is fair in the context of cases against political leaders and military leaders as far as the crime base is concerned, that was achieved. The key to the success that can be achieved under our rules, however, is the awareness of efficiency issues in our daily work, whether it is in preparation for trial or at trial. That is what we need in addition to amending the rules. Common sense. The awareness I just referred to, and mathematics, like in mechanical engineering, are the same in the common law and the civil law world. I used 730 words, including this last line.
Thank you very much, Judge Orie. Now, Professor Papa.
Yeah, thank you very much, President Robinson, and thank you also for the extra time that you allow me to use. And so I'm not going to read just alternate lines, but well, first of all, I would like to stress the fact that I've been invited as a professor of comparative and international criminal law, and this would be enough to recall Nino Cassese as a maestro, as a mentor, as an example for my generation in particular. But I'm not only a passionate scientific reader of Nino's work, I was also a colleague of Nino at the University of Florence, and at different times, Dean of the law school and vice rector of the university. So in some way, I represent, well, not so much the institution, I would say, but a large and transversal community of about 60,000 people professors, students, administrative staff. And it's on behalf of that community that I would like to publicly express our gratitude and pride for having had such a wonderful person with us, and we will miss him a lot, really. Now, coming to the topics that we are discussing here today, I would like to comment on, from the particular perspective of my background. Before getting involved with international criminal law, I was, and I basically remain, a criminal law and criminal procedure professor with a strong comparative law propension. So, my first point would be to say that I totally subscribe to President Robertson's suggestion that there is no fundamental principle of law that requires ICTY to work both in civil law and common law systems. I also agree that it is irrelevant whether the tribunal is a civil law or a common law system. Even more radically, I think that we should restrain from referring so much to these two models, the common law and the civil law, as useful tools to understand, develop, reform criminal procedure today. In general, reference to these two models is most of the time misleading and non-informative. Reforms inspired by the models approach ended up producing most of the time unintended results, and very often results which are very different from what reformers had in mind. So my point is that the models approach produces poor architecture and poor interior designs, so to say. One example is plea bargaining. I think that's a very good example. Since one can never tell whether introducing some form of plea bargaining will be well received in a system or almost ignored. And we don't really know what makes working plea bargaining. And I think, for example, that the structure, size, and work organization of law firms is a very important factor, but has not very much to do with the models. Also, in recent history, we have been watching transformation of criminal procedure everywhere. Almost everybody is claiming to be going towards the adversarial Anglo-American model. Even France, the homeland of juge d'instruction, wants to get rid of the investigating judge. So, however, everybody is going its own way, and the result is a great number of national variations. But even more than this, I think, even besides this, I think that when we deal with international criminal law, we should not forget the achievements and the awareness that we developed in domestic criminal law and procedure, thanks to critical legal thinking, to the reaction against the excesses of formalism, the excessive positivism, and thanks to sociology, thanks to legal anthropology. We should not forget the lessons of legal history that tells us that the law is much more experienced than written rules and logic. So the point is that domestic criminal justice and criminal procedure is heavily based, so to say, on closure. So we see only a small portion of the mechanism. A large part of the machinery is hidden in some way, and we can only guess about how it is. So codes of procedure also, they spell out, so to say, the essential play script of a much more elaborated drama. And the drama, the action of the criminal proceeding, takes place in the real world, in the real society, with many more actors. And the performance of these actors is heavily affected by a number of factors, legal factors, but very often factual, political, sociological. And this is why the shape of each legal system is really unique. So the real challenge today, I think we should not forget that, is to try to understand how each system actually really works, which forces and factors drive the system, where is discretion, how is controlled, to what extent the criminal procedure is affected by its social functions. So I think that this makes really difficult to borrow, single rules, specific rules from one system to the other, and even more difficult to bring these rules and mechanisms into the international criminal law setting. In fact, when we are borrowing rules from a model, we are not really using a model, but we are referring to a given historical experience. And we can now borrow all factors that make the rule and the legal mechanism working in that way in that system. So I think that for all these reasons, it's much better to develop international criminal procedure as something driven by, first of all, its own political foundation, its own policies, its own principles of efficacy and fairness. Abstract stereotypes are useless. What can we say about these distinctions, common law, similar law? Is there anything that can be still kind of useful? Well, I think one issue is to keep in mind the mentality of the people that come from one experience or the other, but not so much. It's more important, I think, legal education that they received in the two different settings than the experience in the criminal procedure itself. And also the awareness of certain connections between segments of the procedure. For example, we know that some rules of evidence depend on the presence of the jury, and we have to keep that in mind. We know that some powers of the judges depends on the knowledge of the dossier. And so when we don't have that connection, we should maybe wonder, well, will it work? We also should keep in mind that some features, for example, the standard of evidence, depends also on the bifurcation between adjudication and sentencing. And we know that that link exists, and we should keep in mind that that might be relevant. Now, always trying to be fast, I think we should keep in mind the relation between substantive law and criminal procedure. So when we consider the criminal procedure, we always should keep in mind what kind of criminal law, substantive criminal law, that procedure is implementing. So we know that the specificity, the peculiarity of international criminal law, but I don't think that the very problem is due to, sort of the context element or the complexity of the description of actus reus in international crimes, or the particularity of the forms of mens rea to be proven. Yes, these are particular features, but I think that the real problem is another one, and it has to do with the fact that international criminal law it's very much focused on modes of liability. So what really makes special international criminal procedure, and what really requires a fine tailoring of the rules of international criminal procedure, is the fact that the criminal responsibility does not attach so much to direct perpetration of the very conduct which is described by the criminal offense, but depends on mechanism of imputed and derivative liability, such as command responsibility, JCE, aiding and abetting. And I would say that even the responsibility for omissions is a doctrine of imputed liability. So, this is the very problem. And from this point of view, I think the work of the ICTY has been really remarkable. Developing a set of rules of procedure, having in mind that these rules should work in relation to modes of liability, as a main reference in substantive criminal law. And so here we have a great legacy. The issue of fairness, well, I think that the work of, just to say very shortly, the ICTY really managed to increase efficacy without serious prejudice for fairness and protections of human rights. Rules like 92Bs are surely problematic, since the principle affirmed is the admissibility of out-of-court evidence. However, one should really question if this rule is really revolutionary. The right to cross-examination should always be respected, and this is the main guarantee, and it's not in discussion. All systems have exception to the principle of orality of evidence. And we do not really know how judges really evaluate out-of-court evidence when, for example, that evidence is officially produced just to impeach witnesses. And we also should remember that many systems have rules of evidence when the issue is not to prove the very conduct of the crime, but, for example, when it comes to sentencing. You know, the sentencing phase is almost without rules of evidence in the so-called Anglo-American procedure. So the system, I think, I totally agree with President Robinson, should have as a main reference, the standards set by Article 14 of the International Covenant on Civil and Political Rights, and the general principles are there, and we have, the case law of the European Court of Human Rights, and in this respect also, I would like to stress that the European Convention was drafted when almost all systems of criminal procedure in Europe were inquisitorial. So this shows that it is possible to consider issues of fairness without any specific commitment to a model of procedure. And in this respect, I think that, and I agree with who spoke before me, that it's not only simplistic, but is wrong to consider the civil law and as a crime control model and the common law as a due process model of procedure. This is, I think, totally wrong. Okay, just a couple of remarks, President. Well, first of all, I think, talking about fairness, we should keep in mind what is happening in other settings. For example, what is happening in other categories of macro crimes, like the transnational crimes, the cross-border crimes. Take, for example, organized crime or international terrorism. Here, what we see today at the domestic level is a significant trend towards a double-track criminal procedure. All systems, almost all systems, are going towards the creation of special procedure for organized crime prosecution. And so these special rules, I think, create problems of fairness which are more serious than the problem of fairness in the international criminal justice. Because these special rules are not drafted in order to speed up the procedure, but they are created mainly to ease the prosecutor's task. So they put in discussion the very basic principle of criminal procedure, the autonomy of criminal procedure as a branch of the law that is not shaped to fight criminality, but to fairly adjudicate the issue of individual responsibility. The very last point has to do with efficacy. I think that I agree that the system is going towards a kind of managerial criterion as a criterion of handling cases, and I think that it would be very important to start some kind of serious empirical research, and I think that we have some good references, and one is the European Commission for the Efficiency of Justice, which has been established under the Council of Europe. I don't know if you have ever see the website of this commission. I think the kind of work there is really useful, whether we want to really understand if some changes in the procedure do have an impact or not, because sometimes, and this is really my last sentence, we might have reforms that speed up the traffic, so to say, in a particular crossroad, maybe a trial, but the general amount of time that has to be used to handle that matter is more or less the same. Maybe we need more preparation for that and less time at trial. So it's really important to verify, to assess the impacts of these reforms with some kind of empirical research. Thank you so much.
Thank you very much, Professor Papa. We'll now take the abbreviated coffee break and return at 11:30 sharp.